106741, State of Kansas v. Thomas E. Jenkins.
Gerald E. Wells from Lawrence, representing Mr. Jenkins, the appellant, and Chief Justice, I would ask for 3 minutes rebuttal.
3 minutes is granted.
Thank you. This is a criminal case on appeal from a first-degree murder conviction, along with an aggravated burglary conviction and a theft conviction of Mr. Jenkins. There are 3 issues today that we filed on appeal. One concerns was there sufficient evidence for a reasonable jury to convict Mr. Jenkins. Secondly, did the district court err by not ordering a new trial for juror misconduct? And thirdly, on a post-trial proceeding, did the court err in finding Mr. Jenkins competent in that post-conviction under Davis? Chief Justice, I would like to concentrate and focus my argument today on the second issue, which is, was there juror misconduct? We would stand on our brief on the first and third claims in our appeal by way of not conceding, but certainly standing on our brief. There are, in this issue concerning juror misconduct, it is an unusual set of circumstances, to say the least, but we believe that the standards of review, and I say standards multiple, the case law seems to support that the standard of review for this court is whether the acts of Mr. McDonald constituted misconduct of a juror, and whether or not that misconduct substantially prejudiced Mr. Jenkins' right to a fair trial.
Isn't it a credibility? I'm confused by that. Isn't it just a credibility determination? The district court heard the testimony from the old juror and heard the testimony from the assistant county attorney and made some decisions, and so now we just look at it as whether there was substantial competent evidence, I suppose, to support it, and then the discretion we would give the judge to make that credibility determination. We can't dial back a credibility determination from this bench.
I was quoting the Mathis case, which we used in our brief, and you may be right to one degree, but the Mathis case seems very clear that there, in the consideration of this court, whether or not, and applied to the district court, whether there was, in fact, acts that constituted misconduct. The other one I would mention to the court is if it is of a constitutional magnitude, and clearly it is because the Sixth Amendment to the U.S. Constitution is implicated, is this court willing to declare a belief that the error was harmless beyond a reasonable doubt? And that comes from the
first,
court.
don't you have to, isn't it, in looking at the cases kind of sequentially, don't we end up with the court has to look at juror misconduct and whether there was a fundamental failure in the proceeding? That's the first step. And tell me where there's a fundamental failure here and how we should look at that.
I think the fundamental failure was not recognizing the extent to which Mr. McDonald, the juror in question, was obsessed with the assistant district attorney trying the case for the state.
At the time of the trial.
Right.
At the time of trial, absolutely the time
And
of trial.
that's where the credibility determination came in, because that's where the district attorney, the district court heard the evidence and said he may be now sweet on the prosecutor, but he wasn't sweet on her at the time of the trial.
Well,
And that's what all the evidence indicated. Where
Well,
are you getting this obsession
right.
that manifested itself, at least in the eyes of the prosecutor, because that's when she started receiving gifts, is when there was an interaction in the courtroom 2 years after the trial, and the juror is there for his divorce proceeding, sees the prosecutor, and then sparks an interest. I mean, that's basically what occurred here, isn't it?
I didn't mean to step on you.
No, that's all right. That's right.
We would differ in that assessment, in that during the hearing, because the court had 2 hearings, and the second one was
there were two gestures made on the part of the
right, and
juror.
which I'm not going to repeat all the gifts, etc., but clearly they were, from a reasonable standpoint, a romantic gesture in both instances. But our theory in this case is that given the testimony, and I think it's page 31 on the transcript, the second transcript, where Mr. Bell, who was appointed by the court to represent Mr. Jenkins in the jury misconduct hearing, he indicates, Mr. McDonald, in answer to a query from Mr. Bell, Mr. Bell says, well, did you formulate, and I'm paraphrasing now, did you begin to have this personal relationship? Did you begin to think about her in a romantic way to send Valentine cards, enough to send a Valentine cards? And did that happen during the Jenkins trial? He says yes.
Well,
Counsel, that's in a sea of denials.
Pardon me?
When you read the entire transcript on that one passage you're referencing is in a sea of denials. And they're not just, no, I didn't do it during the trial, no, it didn't affect my decision in the trial. It's no, no, absolutely no, several times.
I understand. I understand what he's...
And that's, I mean, when that's the testimony, doesn't my colleague have a point? Once the trial judge evaluates that, how do we undo the trial judge's evaluation of that, what you might characterize as one conflict in that sea of denials?
Because it is our point that it was so intensive an obsession that it could not have just started the moment the trial ceased.
So it's an inference you're drawing.
I am drawing an
His
inference,
behavior.
and it has to be somewhat subjective because of the nature of the obsession. And it is our point that if he was so obsessed, and he disregarded every order and every piece of advice that came to him particularly after the first hearing. So that has to say that this didn't start, well, I'm going to be obsessed with this young woman after the trial ends. It is our belief that this obsession started, and he admits to so much in that answer. Now, you can quibble about what that answer means to him and means to the court, but clearly he was obsessed. That's a given. And he rejected every piece of advice and went back and did the same thing again twice. So, using common sense and reason, it is our position that this started during the trial. And I think you could at least take his answer to be truthful. Now, does that affect? How does that affect?
Well, let me,
Sure.
Given that, how does KSA 6441 come into play here when we talk about that it's improper to get into the mental thought processes of jurors and how they rendered a decision? How does feelings towards one of the respective counsel, or whatever feelings they are, enter into isn't that a mental thought process that enters into the decision making that's not allowed for an inquiry?
Well, it did allow for an inquiry, and the mental process was evident from the depth of his obsession with this woman.
And how did that impact how did that impact?
Well, let me back up a little bit. There was testimony that they had investigated and this juror misconduct and spoke to, I think, 6 jurors.
Which turned up nothing.
Turned up nothing. However, if you have this mindset that you are suddenly romantically inclined towards this person and obsessed, and that's not too strong a word here, then you deprive a criminal defendant of the opportunity to have a fair and unbiased juror, because it only takes one. And he was deprived of that right by this person's obsession with, as you say, whoever. But in this instance,
and you know, you've been in the trenches of criminal cases. You understand this. What if there's a juror that ends up just despising one of the advocates? Is the same thing true with that?
well,
And doesn't believe a word that comes out of that attorney's mouth?
that happens, absolutely happens.
And
But
we don't allow an inquiry into that thought process and how that impacted.
But
a
that
jury's
it's not raised in a post-hearing situation where this court ordered a remand not once but twice on that very subject matter. So it depends in the context of what's happened, because this court must have felt that there might be something there that was critical and potentially biased on the part of that juror.
Counsel, what is our, this may have been referred to earlier, what is our standard for reviewing the district judge's determination that there was no juror misconduct?
Well, if there's no misconduct, I don't think it triggers the rest of the standard. I mean, you first have.
Isn't that what the judge found? That there was no misconduct?
He did find that there was no misconduct. We think he was in error in doing that.
I understand that. I'm asking you to tell us what standard we use to review the district judge's determination that there was no misconduct. Is that a question of the amount of evidence?
No,
Or something else?
it is the court's decision based on discretion, in my view. Now, that has been amended somewhat if I read the Mathis case correctly. But, I mean, that's what it boils down to.
So you're arguing that the judge abused his discretion in this determination? I think that's he.
That's correct, because he didn't find an act of misconduct when clearly the facts, as we see it, indicated that.
As you know, we use 3 prongs to define abuse of discretion. Are you saying that this is outside the decision that a reasonable person, that no other reasonable person would make the same decision? Or are you saying that there are not facts that support the decision?
I think no reasonable person would make the same decision on whether or not this was so obsessive that it was a violation of the Sixth Amendment. Now, quite frankly, when I researched this, I came up with the Mathis case, and that's a little bit of a twist on the discretionary power of the court. But there it was. There was Mathis, and also because it involves or implicates the Constitution, Sixth Amendment in particular, it was also a twist on the standard of review for this court. But I would agree that the court has discretion to decide that. They just erred. Judge Helmer just erred in that discretion because of the depth of obsession, the timing of it, and the fact that he was a juror on a case that the ADA prosecuted. And he admitted as much, although I take your point, Justice, that in the context of the entire hearing,
Aside from that one exchange, which is a little ambiguous in and of itself, he was emphatic. He wasn't just saying, no, it didn't affect, no, it didn't happen then. He was emphatic. He said no, absolutely no, more than once.
but he also disregarded every other order that came his way.
In that moment. But
Right.
when they were inquiring about the moment that matters, which is the trial of Mr. Jenkins, he was emphatic that he had no feelings for the prosecution.
But I think you can question that by the fact
Sure,
that
you can question it, but the district judge made a judgment with him sitting in front of him.
he did.
That's what I was
He
trying to
did.
get at.
Yes.
Any further questions? Thank you, counsel.
Thank you.
Okay, may it please the court, Ellen Mitchell, Sling County Attorney. appearing on behalf of the state of Kansas, the appellee in this case. This was a 2009 homicide case, and it didn't go to trial until March of 2011. At that time, the assistant county attorney and the juror in question had never met before, didn't know each other, didn't know of each other. After the jury's verdict was rendered, the prosecutor and myself met with some of the jurors afterwards, as we normally do. They had a few questions, wanted to inquire about, and we did meet briefly with them in a waiting room after the verdict was rendered. There was no other contact or conversation between the assistant prosecutor and this juror until the fall of 2011. We were trying another homicide case. She stepped out in the hallway for a moment. She saw this juror sitting there on a bench. She said hello. He said, "I'm getting divorced. I'm waiting for my divorce attorney." We were in the middle of another trial, and she proceeded on. 3 months after that, she received at the office cards and candy, a poinsettia, and a note about whether or not she wanted to attend a New Year's Eve dance in which a popular local band was playing. She wrote him a note indicating to him that she could not accept those gifts, thanking him, but she could not accept those gifts. And the investigator in my office returned those gifts. He was not home. He just placed them on the front porch, and we don't know what happened to them after that. And we just took them to the address that we had from the juror list, which may or may not have been his address after he was divorced. Nothing happened again until Valentine's Day, and he just called and left a message with the receptionist that he wanted her to have a happy Valentine's Day. And the final contact was a year later, in February of 2013, when a local high school fundraiser where they come and sing you Happy Valentine's Day and provide you with a rose and some chocolate, did so in the front lobby of our office. As the questions from the court have indicated, the state contends that he was entitled to a hearing. There was an investigation, and while certainly we're not supposed to inquire into the mindsets of the jury, we felt it was important that the defendant had a fair trial and permitted it to happen and didn't object to it happening. And Mr. Sheehan conducted an investigation through an investigator as well as himself. And then after the second round, I believe it was Mr. Bell, Mr. Sheehan was removed from the case and another attorney was appointed, and an investigation was conducted as well, and they both rendered the same results. None of the other jurors that were interviewed believed that it had any impact on the case. It is the state's contention that the defendant received a fair trial, that there is no evidence to support that the juror in this case became infatuated with the prosecutor, one of the prosecutors in the case, and that after the judge held the hearing, heard from counsel, and heard from the juror in question, it found that the defendant had received a proper trial, a fair trial, and that there was no juror misconduct. And we believe that his finding is supported by the evidence, by the testimony given, that it's not based on an error of fact or an error of law, and it was certainly a finding that could have been made by other reasonable persons who were sitting to hear this case. We ask that you affirm the conviction and the court's subsequent rulings in this case.
Counsel, were you going to stand on your brief for the other two issues then? Or you care to address them?
I could briefly address them in just that in the first argument, defense counsel the appellant's counsel does not make any specific argument as to what specific element of the defenses was not met. The state does admit that there is certainly a lot of circumstantial evidence in this case, but it certainly does support the jury's verdict. The police left that apartment complex at 2:35 in the morning, and about we have someone who places the defendant there at about 3 in the morning. The defendant denied even knowing where that street was. The defendant pointed out that the upper apartment complex door was open. That's Ben Friedman's apartment. His sliding glass door was open. And by 4:45, Ben Friedman was awake and discovered his apartment had been burglarized, which led to the discovery of the defendant's body in the lower apartment. It's a fourplex. A lot of the evidence came from the girlfriends of the defendants in this case, including the defendant's own girlfriend/wife. She indicated that the defendant had asked her and her friend to make up an alibi for them, and they initially did so, although subsequently she came forward in the fall, about in September, and told the police what she knew about the event, that she had been frightened, and advised that the defendant had been physically abusive to her to prevent her from coming to the police, and had even locked her in a room with her child and had his friends come over, and she told what she knew about the homicide. And he said, if I get arrested for this, CD, my friend whose street name is CD, will be the one that will administer the punishment to you for telling. The defendant and the co-defendants were together at Miss Jenkins' home, at Miss Yannick's home, and at Miss Wellman's, their three girlfriends' home, early in the morning, putting them together. But probably the strongest evidence is that the day before the murder, the defendant, Mr. McSwain and Mr. Bates, are at the defendant's home. The defendant needed money. He had lost his job. Bates said, I know where you can hit a lick. It's over on Johnstown. The occupants will be out of town at a concert. They have money and drugs in the apartment. He had just bought drugs there just before this happened. The roommate of the deceased indicated that they'd had 10 pounds of marijuana and 17 grams of cocaine in the apartment. That day, he had left to go with a female friend for the evening. And when the police got there, there was no marijuana and no cocaine left in the residence. They were able to match the serial number from Friedman's PlayStation to one found at Willie Parker's girlfriend's house. The defendant called his wife, who was parked out in the county with another man, Hassan Williford. He told him that he was sitting outside the place. They were about to go in. He'd call her back. He called back 15 or 20 minutes later. He said that some things had kicked off, but he took care of the situation. And would ask you to recall that, remember, no one was supposed to be in there, and he got a surprise when they kicked open the door. In addition, his wife said the defendant had a gun that he always carried on his person until this happened, and then he stored it in Bates' car. The defendant had been an employee at Russell Stover's, where he had been assigned some work boots that were black and yellow, Service SERV US brand. The police observed that the door had been kicked into the victim's apartment. They used a piece of equipment to enhance the photograph of the door, and they saw the footprint. There were parts of the word service on the door left in the dust. Miss Jenkins also testified that her husband owned a pair of boots like that from his employment, and that a couple of days after this, they went out into a rural area of Saline County and attempted to burn the boots and left them there. At the time of this trial, the boots had not been located, though. And in addition, the defendant almost gives us a confession in the song lyrics where he describes what happens. He references snitching, and it was part of the record that the victim in this case had been a victim in an earlier case, and he had met with the police and given information. And in fact, the police, my office had just served a subpoena on Almac the day before, the Friday afternoon before he was murdered, early Saturday morning. So the state believes that there was sufficient evidence on all of the cases to tie him and his co-defendants, Willie Parker and Justin Letourneau and Justin Graham. And as the court knows, Justin Letourneau was subsequently murdered, and there was evidence in the Jenkins trial that happened, that Willie Parker later committed the murder of Justin Letourneau, who was involved in this.
And what,
And there was
explain,
There was a
go ahead,
ballistic,
Jess.
there was some kind of ballistics evidence, wasn't there? on
There
the gun
was.
used in that murder and the gun used to kill Mac.
That's correct. And there was a shell casing. It appeared from the evidence that The door had been kicked open, and Al Mack was in a chair, and as he started to rise, it's a very small apartment, he was shot. And there was a shell casing right there at the entryway of the door. And we took that shell casing and a shell casing found in the car where Willie Parker killed Justin Letourneau, and matched those, and they came from the same gun, which was another tie-in. Otherwise, the information about Letourneau's murder may not have been part of Jenkins' case, but it was. And it was also a reason I think this court addressed in the Willie Parker's case.
Was that gun found or was not found?
It was not. It
That's
was it was not. It was Willie Parker. It had been disposed of prior to him taking Letourneau to the hospital. And finally, just on the other issue, just briefly, Thomas Jenkins had written a note, and at the Saline County Sheriff's Office at the jail, they read the outgoing mail as part of their security procedures, and they happened to open or review a letter that the defendant wrote, and it had some things that led them to believe that he might be suicidal. He's talking about a poem that he wanted read and what people should wear for the funeral and that sort of thing. And so out of an abundance of caution, Nurse Beth at the jail contacted defense counsel and said, we have this concern. We've got your client in suicide watch. He should be evaluated. And that's what happened. And no one had observed any behavior or anything that led them to believe that the defendant had a serious mental illness. We were just concerned that he was...
Well, did counsel file a motion? His
Def-
counsel filed a
yes,
motion.
yes.
The court granted that motion.
It did.
Ordered a mental health evaluation.
Stayed,
And then it just goes away.
and
Nothing happens.
unfortunately, we failed to make a record and come back before the court after that happened. And instead, we just kept moving and didn't make a formal finding on the record. And so that's why we had agreed, did not contest when the court remanded this back. This case is different than other cases might be. And this is not a case where the defendant was actively hallucinating or saying or doing unusual or unique or bizarre things in the courtroom. We were just acting because based on the recommendation of the sheriff's office that they believed he might be suicidal. The defendant denied being suicidal, and in fact wasn't happy that he was in suicide watch for several days. And as soon as they received the letter from the mental health center, he was released, although he was kept in the booking area. He was giving his clothing and things back, but he was kept in the booking area for a little while longer. And so under the facts of this case, because we had the evaluation and because we were really just acting out of an abundance of caution to make sure that the defendant was fine and able to assist in his defense and not suicidal, we were able to have a retrospective competency hearing. And
well, the key to is the four factors that the court pointed
Correct.
out, but it's you had the evaluator present, you had her evaluation, you had the nurse at the jail, you had defendant's trial counsel, the prosecutor, and the judge who presided over the case.
that's correct.
Every one of those were present and testified in the retrospective hearing. Isn't that right?
That's correct. And so under the facts of this case, we believe that it was appropriate in the
Well, that it's certainly
Order.
feasible to have a retrospective hearing
It
given
was.
the parties that were present.
it was. And everyone's testimony was generally the same, that they had not observed or seen, or he had not done anything in particular. It was just based on that note. And he even denied that it was a suicide note or that he meant anything by it. He said it had to do with something else, some other kids that had vandalized a cemetery. But in any event, we just did it to be cautious. The nurse was concerned. Her concern was addressed. He was placed back in the general population, and we proceeded, although we should have proceeded on the record by making a formal finding. But Judge Thompson did that later, and Judge Helmer was able to testify, as well as my assistant and the jail staff. So we'd ask that you affirm the decisions that Judge Thompson rendered on the competency issue as well.
Any more questions? Thank you,
Thank
counsel.
you.
Chief Justice, we'll waive rebuttal.
Would you mind standing at the lectern so people watching online can see who's saying that, please?
I keep forgetting that. We'll waive the 3-minute rebuttal that we originally requested, Chief Justice.
Thank you. Anybody have any questions? Thank you. Thank you both for your arguments this morning. The court will take this matter under advisement.